Well, good evening, everyone, and welcome back to AJ101 Criminal Law Online. We are in week 17, and tonight's lecture is going to be in two parts. The first part is going to be a chapter that I added, which will be chapter 15. I'm sure you know that the textbook only has 14 chapters. I felt this is a very important uh, topic to discuss as it relates to criminal law. So I added the 15th chapter on witness ID. And then the second half is going to be a very short lecture exercise, if you will, on why memory can be fallible. And we'll get into that a little bit later. So let's go ahead and jump right into um, chapter 15, witness ID. Now, what is the number one cause of wrongful convictions? Well, before we get into that, I'm going to put a little X in the word wrongful, and I'm going to talk to you for just a couple of minutes about why I do this. If we use DNA as an example, we know that there have been individuals that have been arrested, tried, and convicted only later on, maybe even years later, to be adjudicated from their case or found not guilty or found that they were the ones that actually didn't commit the crime through DNA. And the reason for that is typically because of the technological advancements that have been made in the processing of DNA. In today's law enforcement and laboratories, we have a lot of technology and we can process things today that we couldn't process years and years ago. So understand that years and years ago, when a judge, if it was a bench trial, or the jury, if it was a jury trial, all they had to go on was whatever physical evidence that was brought before them in the trial, statements from victims, statements from witnesses, including witness identification. So I just wanted to add a little context to that, that while we know that those witnesses, or the majority of them, didn't convict somebody on purpose. Their motive wasn't to convict someone. They truly believed that they had identified the person that committed the crime, and therefore, sometimes it was found that they weren't the person. So with that being said, we're going to talk about misidentifications and why that they are the number one cause of wrongful convictions. And we'll also talk a little bit about how do we develop witnesses if there perhaps isn't one at the scene. So let's jump right in. Now, in most cases, there is no suspect initially. A crime is committed, the suspect has already fled, and it's your job when you get there to find evidence and collect evidence and process evidence and talk to witnesses and talk to victims in order to help develop a possible suspect. Many crimes are not witnessed. As I just said, take for instance a residential burglary. If someone breaks into someone's home and takes some items and leaves, a lot of times there's no witness to that crime. And therefore, it's a harder case to work because you don't have a lot of things to go on. And some of those things that we go on, if you will, are some factors that are crucial to resolving criminal investigations. Those are solvability factors. And when we get a bunch of cases in the investigative bureau, we work those cases a lot of times based on these solvability factors, meaning like, is there any type of physical evidence? Did the victim happen to see anything? Were there any witnesses to the crime? And those solvability factors are important. And along with that, of course, in order to prosecute your case or make your arrest, etc., you have to be able to prove the elements of the crime. And along with that, you want to be able to establish evidence connecting that suspect that you develop. And we'll look at some ways that you can develop a suspect with that criminal act. So one way that is typically done is something called a field show up or an in-field ID. And this is where if a suspect is apprehended while committing a crime, you can have the victim or the witness identify the suspect. And the same is generally true if the suspect is apprehended at or near the crime scene. So an example could be, let's say someone walks into a liquor store and they go over to the cooler where the beer is and they grab a 12-pack and they run out, commonly known in law enforcement as a beer run. And the suspect flees the store. The clerk behind the desk calls law enforcement, gives the law enforcement a description of the person, and lo and behold, the officers responding, they happen to see somebody matching the description, and now because they have reasonable suspicion to stop the person, they detain them, and they basically will bring the witness or the victim, that being the store clerk in this case, over to where the possible suspect is being detained in order to identify them. And that's why they call it a field show up or a in-field ID. Now, most police departments, we always typically bring the witness or the victim to the suspect. We don't bring the suspect to the witness or the victim, because even if you look at this photograph right here, even if you look at this, I mean, it can be a little bit concerning in the fact that we might be creating visually that, hey, this person must be guilty because, well, he's handcuffed, he's detained, he must have been the person that committed the crime. So we have to be careful with that. Therefore, that's why we typically transport the victim or the witness over to where the suspect is. Now, the critical element for this field show up or in-field ID is time. The identification usually must occur very soon after the crime was committed, and we kind of like to say 15 to 20 minutes, but it can't be a couple hours later where you're driving around later and you find someone that matches the description. You might have to do a different type of identification, whether it's a photo ID or something else. But for a field show up, for that in-field, it needs to be very soon after the crime was committed. And a case that goes along with that from 1973, United States versus Ash Jr., established that a suspect does not have the right to counsel, or an attorney, if you will, present during a field ID, because this is typically just a detention where you're bringing the witness over to make an identification. And of course, for law enforcement, remember, before questioning a suspect, you have to remember Miranda is going to come into play as well. And again, we don't want to make this too prejudicial, but I wanted to show you this photograph because we're trying to get an ID in the field, but at the same time, we're trying not to make it look too prejudicial or that the person is guilty. But if you look at this photograph, again, it can seem a little bit prejudicial, if you will, but that's typically how we do things, at least in California. And, you know, states are somewhat similar, but sometimes they're a little bit different. Now, when we're talking about developing suspects, there's a lot of different ways to do this. And I'm not going to go in real detail into this. I just want to kind of touch on some areas for developing suspects because, again, as I said at the beginning of the lecture, a lot of times, the majority of the time, there is no suspect at the scene. So how do you develop a suspect or find one or identify one? Well, if a suspect is not at the scene and not apprehended, again, you have to develop one. And they're developed through a lot of different ways. At other times, the victim or witness or witnesses can provide the required information that you need. Then your task is to corroborate the identification through evidence like fingerprints and shoe prints or personal belongings, etc. So in the case of the beer run, if we go back to that, one way to corroborate that victim or that clerk's identification on the person that took the beer and ran would be maybe that the person had the beer in their possession, and that would be the evidence. Does that kind of make sense? Or the baseball cap that was red, or different types of clothing or things like that. So these are things that we can use to help corroborate the identification. And that would be through, again, associative evidence like fingerprints, shoe prints, personal belongings, etc. Developing a suspect is much easier if the victim or witness can describe and identify the person. So hopefully they get a good look at the individual. And rather than simply asking a witness to describe the person, you as the officer, you'll be trained on how to ask specific questions and ask a lot of questions. And obtain information about how the suspect left the scene, like on foot or on a bike or in a car. These are all important pieces to help you develop suspect information. And witnesses may not have seen the actual crime, but might have valuable information, like a partial license plate. So maybe they didn't see the person break into your neighbor's, into the house, but they saw the person climbing over the fence. So they have a description of the person's clothing or something like that. Or they saw them get into a vehicle and they got a partial license plate. Nowadays, with technology the way it is, they may have captured it on a cell phone, or the homeowner may have cameras in their home. All of these are important ways to develop suspects. And remember, eyewitness identification is highly fallible because of a lot of different factors. And I'm not going to give you the laundry list, but some big ones would be poor visibility, or the witness or the victim only saw the suspect for a very short time, or the distance was far away. And then keep in mind that a lot of times, people have faulty memory. They can't remember things crystal clear based on whatever happened. An example could be if a store clerk in a liquor store is the victim of a robbery and the suspect points a handgun directly at their face. Do you really think the clerk is going to remember every item of clothing, perhaps, that the suspect was wearing? They might have tunnel vision and focus in on the firearm and not really remember a lot of other things. So all of these things are factors that can make our identification fallible. Booking photos. This is one way, not often done, but one way to develop a suspect. If the victim or witness does not know the suspect but saw the person clearly, you could make identification through some mugshots, as we call them, or booking photos. It is a little time consuming, but that is one way. Composite drawings are another one, or sketches. Now, years and years ago, we actually had sketch artists, and they would freehand sketch the description of an individual, and then it kind of morphed into, we had these little plastic sheets, and there would be like little lips on them, or eyeballs, or noses, or hair, and we would lay these sheets on top of each other until we built up a composite. Now, with the technology the way it is, we can do these on our cell phones or an iPad or in the car on a computer, because the software is all computerized. And it kind of shows you something like this. So here is a composite sketch, and the title of the suspect is Young Chief. That's supposed to be me. It was done by students in the MSJC Criminal Justice Club. More information on that to follow. But they worked off of a photograph, and they came up with a composite sketch of me. And while the hairline really didn't do me justice, the rest of it actually isn't too bad. So this shows you how far things have come along on the technology aspect with composite sketches. And we can take that sketch and put it out to the community or put it out to the media to alert them of different types of crimes that are taking place by different suspects. Another way to develop a suspect is through what we call MO, or modus operandi. And this is where a series of crimes typically create a recognizable pattern, or MO. For instance, a burglar may use the same point of entry into homes, or only take certain types of property. And this MO can help with investigative leads. A lot of law enforcement agencies have what they call an MO file, specifically on MOs that are very unusual. And because, again, this can be something that someone does, that's their trademark, if you will. Now, this is different. This MO isn't why they committed the crime. The why could be thrill. They like the the thrill of committing a crime, or they're a drug addict so they need money, or whatever. That's the why. Okay, but the MO is basically, again, the recognizable pattern or the way the person committed the crime, not the why. Geographic profiling. This can be very helpful in identifying suspects who commit multiple crimes. And based on the fact everyone has a pattern to his or her life or where they live, particularly in relation to the geographical area that he or she frequents or lives. So an example could be Colonel Russell Williams. This was an individual that was a high-ranking military official, and basically was involved in burglary, rape, and murder. And you can look at the locations of the different crimes that this person committed, and you can see how it's along certain roadways and in a certain general neighborhood or vicinity. And that's one way that you can help track or identify a suspect. And I wanted to throw this in because it's just interesting. While it doesn't completely fit with what we're talking about, it is something that's very, very important, and it's called a pretext stop. And this is where an officer stops a vehicle when their intent was not the real reason for the stop. They wanted to stop them for something else. So the best example I can give you is that you receive information, let's say from a narcotics officer from a neighboring city, that you have a vehicle coming through your town that has a load of cocaine on it, let's say. And he gives you the vehicle description and the suspect description, and you happen to see the vehicle, or what you believe to be the vehicle. Now, your real reason that you want to stop it is you want to get in you want to stop the car, you want to identify the driver, you want to develop probable cause to search and arrest and find the drugs and make this awesome arrest. But you really don't have right now any reason to stop the car other than some information. So basically, you follow the vehicle then until the vehicle or the driver commits a traffic violation. Which is an infraction, but it's committed in your presence, and that gives you reasonable suspicion to pull the car over. So let's say they run a stop sign. So you're going to stop them for the stop sign violation. However, you know that the real reason you're stopping them is because you want to find the drugs. Now, it's an interesting piece of law. The case was in 1996. It's Wren versus United States. And the court basically took a look at this similar situation and basically came up with, or came to the conclusion that, you know what, they don't really care why the officer stopped, what their intent was to stop the car, as long as you had a lawful reason to do so. So even though you knew that the car might have drugs in it and the driver was a courier or somebody, let's say, transporting narcotics, as long as you had a lawful violation to stop the vehicle and then you develop probable cause for the search, the court didn't care because you did it within the confines of the law. So I have a link on there to the actual case that you can look at to get a little more information, but this is a very unique point of law when it comes to dealing with these things called pretext stops. So a little bit more now, we'll jump back into developing suspects. Tracking footprints can provide valuable clues. The length of stride and depth of the impression can determine the height or the weight of a person. Or you can simply identify someone based on the pattern of their shoe, their boot, or what have you. And tire tracks are similar. They can also provide information to investigators like direction of travel, etc., but they can also be linked to a certain tire on a certain vehicle that a certain possible or person of interest might be driving. So these are all things that are very, very important when it comes to developing suspects. Some other aids that you can use would be yearbooks. You could go back and you could look in a yearbook or have somebody identify a potential suspect by looking at a yearbook. And if you look at the one right here, that's Will Smith. Anyway, not that he's a suspect, but I thought I'd throw that in there. Dental records or orthopedic records. This is another means of developing or identifying a suspect. And then lastly, with developing suspect, information in police files from other agencies. Now, police files on those who have committed crimes, both actual suspects and those suspected of crimes. A lot of times officers will fill out these little cards known as field interview cards, and maybe they didn't arrest somebody for a crime, but they thought they were involved in some criminal activity. They couldn't really prove it, but yet they filled out this card, which indicates the person's personal information, their name, their address, their date of birth, what they were wearing, why they were stopped, etc. And those are put into a computer bank, and that can actually help you develop a suspect as well. Interagency information sharing and informants, all of these things are very good to help you develop a suspect. Now let's look very quickly at some types of identifications. There are three main types. Now I underline booking photos because it's a way to find information, but it's not really one of the three main types. The three biggies that we're going to look at are going to be field or show up IDs, which we kind of went through at the beginning, photographic IDs, or lineups. And those are kind of the big three. Now, the field or show up identification, or in field, if you will, again, we kind of covered this at the beginning, is where a person is detained based on the officer's reasonable suspicion that they're involved in some type of criminal activity. And at this point, we're going to have a witness or a victim come over to where this person is being detained and make an identification. Now, I talked a little bit before about trying not to make it look too subjective, that the person might actually be the suspect, but this is typically how an in-field ID is done. And again, this is where the suspect is shown to the witness. It's usually right after the crime occurs or within a very short period of time. Remember, we talked about, say, 15 to 20 minutes or 10 to 20 minutes, right around in there. Officers, again, will usually bring the victim or witness to the suspect. And we will also read the victim or the witness a admonishment. And we're not going to spend a lot of time on it, but here's an admonishment from the Rialto Police Department, where I was police chief, that talks about in-field show up. And we read this admonishment to them just to let them know that, hey, we're showing you a person, and just because we're showing you this person, it should not influence your judgment, meaning it may or may not be the suspect. The persons who committed the crime may or may not be the people that you're viewing. So that kind of makes sense. We want to get that information out there to them. And then we tell them, hey, study the person carefully before making any comments. And you're not obligated to identify anyone. And that's really important, because a lot of times people think that they're obligated to make an ID, and they're not. If it's not the person, it's not the person. And that's one of the reasons that we show them this particular form. So the next type of ID would be a photo lineup, what we call, or a six-pack. And we call it a six-pack not because it's a six-pack of beer, but because it's a six-pack of photos. And typically the six-pack might look like this. And there's a lot of different things that go along with the photo lineup here. Or this six-pack. We try to, or the courts have told us to, make sure that we get people that are similar. And it could be similar hairstyles or hair colors, or weight, especially if someone might have a chubby face or something. Or, we try to make them similar. So if your suspect had red hair, we would put everyone, let's say, with red hair. And it would be unfair to have 5 red-haired individuals and 1 blonde, because then everybody would automatically kind of focus in on the one that's different. We do have a little bit of leeway, where if the suspect had a scar, we can actually Photoshop in a scar, or a little tattoo if the suspect had a tattoo, because you're not going to be able to find everybody with the same tattoo on their face, if that kind of makes sense. So this is a photo lineup, so we get a little bit of leeway on this. Photos can also be obtained through, we have computerized booking photos, California driver's license data banks, or surveillance. And I just threw up OJ's photo in there because this was a booking photo for him, but we can use these photos as well. So for a photo lineup, again, multiple photos, typically 6, are shown to the witness or the victim in groups or in sequence with the suspect included. And I'll talk about the difference on group or sequence in just a minute. Many departments, again, use a 6-pack photo display of mugshots like I showed you, or other photos. Officers, again, will read the victim or witness an admonishment. And the 2 types of photo lineups, if you will, are sequential and standard. And standard, and well, here's the photo lineup with the admonishment. And I'm not going to spend a lot of time on that, but I wanted to let you know that we had a photographic lineup admonishment. So here's a standard photo lineup where you're going to look at 6 photos and they're all pretty much the same size, and you're going to show these photos and you're going to have the person identify someone. Well, a lot of courts now are saying that, well, you know what? The problem with this is people start to compare. They think it might be number 1 or number 2, but they're not sure, so they start eliminating people, kind of like a testing process when you take a multiple choice test, and you start eliminating until you get down to 2, and then you just kind of decide. And you're pretty much, your thought process is, well, they're showing me this photo lineup, so the suspect must be in this lineup. So it's like taking a test. So to make it a little more fair, the courts are leaning more towards what they call sequential. And sequential is we show you those same 6 photos, but one at a time. We still do the admonishment and everything else, but we show you one photo and you either identify them or not, and we show you the next photo, and we walk through the series of photos, if you will, and that's a sequential one. And that's basically deemed to be a little bit more fair. And then the last type of ID that we'll talk about would be an actual live lineup. And this is where a group of individuals are brought together, and the victim or the witness views them live in a room. And commonly used, of course, when the suspect is in custody and there were witnesses to the crime. At its most basic level, a police lineup involves placing a suspect among people not suspected of committing a crime. And typically from 6 to 10 people is the standard, and they too may be standard where you have all 6 to 10 at one time, or sequential, kind of like I showed you the one photo at a time. Well, they might have one person walk in, turn around, face you, maybe even, say something. And it's similar to photos. You want to kind of dress everybody similarly. They don't have to be exact, but again, you want to have 6 to 10 individuals that sort of look the same. Does that kind of make sense? I included a link in here. If you want to go and learn a little bit more about a sequential lineup, you can go ahead and take time to do that. And again, so still staying with the live lineup, suspects must be similar, not of a different race, exceptionally taller or shorter, have longer or shorter hair, be dressed very differently. If the suspect had a red cap, we would put a red cap on everyone. They can be asked to step forward, turn around, and even speak, as long as everyone else does it as well. So if the words were, "Give me the money," with some expletive after that, you can have everyone say that phrase. And suspects, they can refuse to participate in this lineup, but refusals can be used against them in court. And there's a case on that in 1966. It's Schmerber versus California. So just to kind of end up here, when you look at both of these lineups here, the one on top is one that satisfies due process. Again, not everybody's going to be perfect, but if you look at the one on the bottom, that one is a little bit suggestive because you have a young lady in there, and that doesn't fit because they were all men. Let's say it was a male suspect. And this, kind of a funny one here, but if you had everybody dressed like this and then you have the poor guy in the middle, again, that would be an unduly suggestive lineup. So that's it for the lecture on witness ID. And coming up shortly, I'm going to jump in very quickly to a little exercise that we'll do together that gives you a little bit more information, more specifically on memory.